Um, Welcome, ladies and gentlemen. Welcome to the panel session on the role of public finance in implementing the guiding principles. I'll start with a note of apology. We're running slightly late today. That means that timekeeping is going to have to be kept especially rigorously, and I'll certainly undertake to do my best to keep good track of that to maximize the scope for comments. My name's Mac Darrow. I'm the Chief of the MDGs section in OHCHR, and it's my great pleasure to have been invited to moderate this session with such a distinguished panel, and indeed such a diverse and distinguished group of participants. I think most of you perhaps were at the panels that have already taken place, and you know the drill. I won't need to go through it in great detail. There's a table over to that side of the room, my left, where during the course of the presentations you're invited to walk up and note your name on the speakers list. There are 3 columns for different types of speaker. Please don't enter your name more than once in more than one column. And then the speakers will be invited when the time comes off that particular list. There is no other way to take the floor. The speakers will have 7 minutes, strictly monitored, to talk, and 2 minutes from the floor, as for those of you who haven't been part of the previous sessions. In this room, we do have interpretation in English, French, and Spanish, and when speaking, I'd invite you to speak clearly to make life easier for our professional interpreters. Moving straight into the topic of discussion, this session will identify trends and challenges in promoting the guiding principles on business and human rights and policy coherence in the context of public finance. And the participants here represent perspectives from international financial institutions and also export credit agencies as key engines for public finance. The topics that the participants will cover today vary across a wide range of issues, including safeguard policies, bearing in mind, in particular, the World Bank's ongoing safeguard policy review, which has just been publicly announced, as well as recent experience from the European Investment Bank and Inter-American Development Bank. Issues such as due diligence measures, engagement with investors and sponsored projects, organizational arrangements within institutions to enable due diligence and dispute resolution, stakeholder engagement, and grievance mechanisms. We have a strict time limit of 3:45. The next session after this, the final session of the day, starts strictly at 4 p.m. So we'll be taking questions, dealing with discussion as best we can by 3:45 sharp. Without further ado, I'd propose to go into introducing the first speaker, which is Maria da Cunha, who's the lead safeguard social development specialist in the Inter-American Development Bank in the in the ESG group. Maria, perhaps I'll let you, in fact, unravel that acronym for us. Maria is a development practitioner with more than 25 years of experience in development. She was one of the principal authors of the Inter-American Development Bank's social safeguard policies, and has been a senior member of the Inter-American Development Bank's legal and technical teams dealing with various facets of development projects, including evaluating environmental and social impact assessment, information and mitigation plans in compliance with IDB policies. She has many years of experience in implementing those standards, stakeholder consultation, conflict resolution, strong focus on indigenous people's rights in this regard, and resettlement issues. Without further ado, Maria, I would invite you to take the floor and present the IDB's experience and some of the challenges you face on these issues and any great ideas that come out of your experience. Thank you.
Is the mic on? Good afternoon. It's an honor and a pleasure to be here with all of you and to talk to so many people who have common interests in social safeguards and in human rights and in many of the items that have occupied my personal agenda at the IDB for so long and which are really at the center of the development work that these institutions do, even though there are competing interests that make our work sometimes challenging. At the IDB, as an MDB, MDBs have policies that respond primarily in a progressive way to a requirement or a demand from stakeholders that they, within their economic mandate to provide economic development in as apolitical a form as possible, to protect and respect rights and human rights and the laws of those countries with which they operate, both donors and recipients. The human rights agenda, therefore, was considered to be originally more political, and it's not articulated clearly in the policies of the MDBs, but the principles and the substance of the safeguard policies and of other development policies, in fact, are very coherent with the goals of the principles and of the human rights agenda. And for us, as we move the discussion on human rights to the economic arena rather than the strictly political arena, this reopens the discussion of how to better articulate MDB standards in a more direct fashion to incorporate human rights more explicitly. This does not mean, however, that MDBs have not supported human rights, the human rights agenda in many ways, both as part of, at IDB and others as part of their core activities, such as support for health, education, and basic services, housing, access to water, sanitation, etc., but also specifically in certain areas such as gender equality, support for projects that seek to prevent and control the trafficking in persons, an area that IDB has been active on with technical assistance, prevention of family violence, youth programs, justice reform, both in terms of access, professionalizing the justice profession, supporting ombudsman functions in certain industries or regions in countries where there is conflict that makes development difficult, human rights training directly for public forces, citizen security projects, and many other projects that speak directly to governments' efforts to improve their practices and their ability to protect human rights. Also, more recently, agendas having to do with health and food security, more directly, the right to materialize certain human rights. As we speak today, IDB is carrying out in Japan a dialogue with NGOs, some companies, and development actors that tries to capitalize on the opportunities to work directly with communities through the Japan Fund for Poverty to address questions of poverty alleviation and community development in general. So as the human rights agenda and the principles implementation moves forward, we see that several strategic opportunities to integrate this agenda more in our country programming and support, and therefore support national human rights policy frameworks to consolidate our safeguard practices and close any gaps that might remain in social assessment. I will speak a little bit more if my time allows me about our safeguard policies, and whereas they do cover a lot of the basic rights, there are some gaps because they developed as sectoral or topic-specific policies rather than as a comprehensive framework on human rights or a rights-based framework. And then to also explore more this space, especially for IDB, which works with both the public and the private sector, to explore more this space where we can leverage our capacity both in the public and private sector to support government, business, and community actors to work together in strengthening protection, respect, and remedy for human rights as part of creating a more enabling environment for economic development and for development in general. So in terms of protection, the main agenda of the IDB is articulated in its safeguard policies. And whereas the safeguard policies have a sort of sectorialized logic They address environment, resettlement, indigenous peoples, genders separately. Fundamentally, they seek to provide the similar minimal guarantees as the general principles, looking to protect rights, to ensure that livelihoods are not harmed and are improved when projects affect people, that equal treatment is given to project stakeholders, and that self-determination is respected through consultation and engagement with stakeholders. The bank policies, the safeguard policies that deal with this are the environment policy, which supports legal compliance, including compliance with the fundamental rights of workers and the human rights framework, consultation, and impact and risk assessment as the pillars that generate these strategies to prevent and mitigate impacts. Social impacts that are covered under the social impact assessment of the generic environment and safeguard policy that are not addressed by specific policies, including impacts of migration, protection of cultural assets, both tangible and intangible, labor issues, certain livelihood impacts that are not generated, that do not affect indigenous peoples, are not generated by resettlement specifically, resource loss and conflict in general, this question of unequal burden of displacing work or the burden of certain changes to a particular group in an unequal way, impoverishment risk, and then perhaps the more intangible risk of marginalization, or not necessarily being harmed by a project, but being left out of a development process that eventually increases rather than close the gap on the poverty gap or the well-being gap in a particular country. We also have a policy on indigenous peoples that also focuses on respecting, on the safeguard side, on respecting the rights of indigenous peoples and avoiding adverse impacts, in some way bringing some specificity to some of the safeguards that are already covered in the environment policy, but with special attention to the particular cultural aspects of indigenous communities as well as to their rights. And then that policy also has a proactive side, being part of a new generation of policies that seeks to promote or support indigenous development with identity. We also have a resettlement policy. It's the oldest of our safeguard policies that address specifically the impacts of relocation and try to ensure that relocation and rehabilitation are carried out in such a way that people are left at least as well off as they were before the project, but hopefully better. And our most recent policy, which is the gender policy, which addresses primarily mainstreaming of gender equality, but also contains safeguards. It was a difficult debate within IDB and outside to include safeguards for gender, but basically they landed on making sure that unequal benefit access and unequal burdens are not placed on people as a result of gender differentiations, and that restrictions in on access to labor benefits are not based on family situations, and also focusing on the special needs of women as far as health and access to land ownership. Our consultation requirements underlie all of these policies. I will not dwell on them because I'm out of time. And we have an accountability mechanism which allows for people to access the bank for both consultation or ombudsman and negotiating phase, as well as through a compliance panel. There are some implementation challenges in that, which we can discuss perhaps more in the question and answer, which have to do with accessibility. We find that we are getting, the people accessing the panel tend not to be the most vulnerable because it's difficult, so it's a cumbersome process to access the panel. There isn't a whole lot that we have figured out how to do to make it more accessible. It's open, it's transparent, but it's a question of local capacity. And we are also trying to promote the growing use of operational level grievance mechanisms in our projects, and that is something that's actually advancing quite well, especially in the private sector. And there are some more difficulties because of mandate and budget issues in the public sector. So as we look to gaps, we see gaps mostly in application more than in substance with respect to human rights principles and the substance of the rights themselves. And as far as the trends and the future, we look for opportunities to support the process through capacity building, through better access to remedies and justice in general, through being a player in the field of better transparency and coherence, by disseminating information and doing research, by working more in the area of fair benefit distribution and benefit sharing, and again, by leveraging our position, especially at IDB, as a player in both the public and the private sector, to bring together CSR, official development aid, and social spending in the countries, and community demands in a space that can bring all these things together to provide for a more robust model of development. And also, we look forward to a rights-based approach where we might stop talking about whether to do things, but how to do them.
Thank you very much, Maria. I think that last question of yours is certainly the direction that we wish to go in conversation. It's salutary to look at the IDB's experience coming from a region where the human rights tradition is comparatively rich, where the institutions are comparatively well developed, and to see what implications there are that arise from that in the way that human rights are internalized in an institution like the IDB. The same might be said for our next speaker, coming from speaking from the perspective of the European Investment Bank. Eleni Kiru is a social development specialist working on environment, climate, and in the social office and the projects directorate of the EIB. She has rich experience in the field of development generally, from the Global South with civil society organizations, academia, multilateral organizations. And as a social development specialist for the EIB, Eleni is responsible for the appraisal and identification of risks in investment projects and subsequent monitoring. As part of her current job, Eleni is also involved in the internal safeguards policy development in the EIB and the elaboration of associated procedures. And Eleni will be talking us through exactly how some of those regional human rights instruments relate to the context in which the EIB is developing policy in this area, looking at the drivers behind the EIB's human rights integration and the scope of the EIB's human rights integration. Eleni.
Yes, and I'm going to do that all in 8 minutes, 7. So I'll take the first 30 seconds just to bring everybody on the same page of who we are. So I'll be minimalist, but giving you the main facts. So we are very much in the woods, literally and figuratively, sitting in Luxembourg. Within the European architecture, institutional architecture, we are the investment arm of the European Union, with an annual portfolio last year of about 60 billion. Most of it, 90% of this being spent within the European Union, so within EU 27 member states, and about 10% being spent outside. Now that outside, we spend according to the instructions we receive from the European Parliament, just so that you understand as well the decision-making that guides that spending. So we receive regional mandates from the European Parliament that dictates which countries and which sectors are going to be supported through our work. Key in that for our discussion is that the EIB is not a policy setter or a policy, we do not determine policy as such. We receive policy and we enact it. So our room for maneuver in that respect is fairly limited. And as a public body, so an EU body, we are subject to the laws and regulations, soft and hard, of the European Union. We finance both private and public sector, so moving around across the two worlds. And the standards that we have in terms of the social safeguards very much echo the safeguards, the standards of other fellow IFIs out there. And we endorse their universal applicability, whether we speak about them guiding our actions within EU 27 or them guiding our actions outside the EU 27. So that was a bit about who we are. Final piece of information, largely we perceive ourselves as an investment bank. So the links to development are quite tenuous, and they're supported by the fact that only 10% of our portfolio being spent outside the EU. Now, talking of the drivers behind our work and the recent revision of standards that we have embarked on, we coming from a very different angle. So being institutionally subject to EU legislation, we are subject and we're guided by the Treaty of Lisbon. And that Treaty of Lisbon, since 2009, I believe, has endorsed and awarded legally binding power to the European Union's Charter of Fundamental Rights. So for us, it wasn't a matter of choice or voluntary endorsement, if you wish. It was very much a legally binding factor out there that compelled us to review our standards with respect to human rights provisions within the Charter. And in that sense, the Charter became as well the primary instrument of legal instrument of reference for our work. It coincided very conveniently with the development of the general principles on business and human rights and their 2011 endorsement by the European Commission as well. So the GPs as well came into our spectrum. It wasn't something, so we played with, if you wish, we played with these two frameworks of reference, trying to understand convergence and synergies for our work. Let me go back one step before that revision to emphasize that our statement on environmental and social principles and standards, even since its last revision, but back since 2000. So 2000 was established, 2009 was its last revision, does entail explicit reference to a rights-based approach, and the 2009 revision entails specific reference to the Treaty of Lisbon and the Charter. So we understand that our work was always being guided by a rights-based approach, and our guidance notes, so the written documents that guide our work in the social impact assessment of our lending, have numerous references to human rights provisions. Nonetheless, we embarked in 2011, beginning of 2011, to that revision, and one of the first things we did is we came and saw MAC, and we sought guidance from the Office of High Commissioner for Human Rights, amongst other actors out there. So what we did is we embarked on a path that was quite similar to what IFC did. So we undertook a gaps analysis that helped us appreciate what is the difference between the provisions that are out there within the Charter and the Ruggie framework and our gaps. And I'll quickly take you through our main findings. So first of all, that gaps analysis tried to understand whether a particular right is relevant to our work. So there was always the question of relevance. There was a question of whether that right was explicitly or implicitly targeted in our current documentation, and the depth to which and the adequacy to which that right was targeted. And we also tried to understand and appreciate whether the possibility exists to add relevant and additional content to that to our documentation in order to make a respective right fully addressed. In our principal findings, what we came across is that the right discourse already underpinning our documentation was in place. So that gave us a sense of initial comfort to start with. And what we appreciated is that what we came across also was that the majority of rights were highly relevant, and we can discuss the whole relevance question if you wish later on. But we also came to see that our practice differed from our theory, but in the inverse way of what someone would anticipate. Normally you think that there is a lot of lip service paid in such documentation, but in terms of practice, there is much less done. And what we came across is that we actually do a lot more that is not explicitly addressed in the text. So we felt that a lot of tacit, a lot of explicit embeddedness of human rights should be done in our work. The review is ongoing. It's probably going to enter the stage of internal consultation within 2013, and slowly towards the second half of 2013 going and reaching external stakeholders. I'll finish off with challenges and dilemmas, and I'll just put them as bullet points there. The first one is universality versus context specificity, how we can appreciate context within our work. The fact that whether we like it or not, we live in an imperfect world and there are no overnight miracles, so do we ascribe to progressive realization of those rights within a project cycle, or do we want perfection at the outset? How do we translate all those standards into operational instruments? And there is a whole wealth of work to be done out there. What are the differences between a robust due diligence process and human rights due diligence, or an integrated or human rights responsive due diligence? There are many more, but I think I'll stop there. Thank you.
Thanks, Eleni. I'm sorry to have cut you short there, but thanks very much for keeping to time. It's interesting you're starting to home in on some of the drivers of policy change within the EIB, and it's interesting, again, that overarching institutional context within the EU, and the EU Charter in particular being regarded as binding. Be intrigued. Lawyers don't often have a lot of clout in powerful organizations, and so I'd be curious to know how that one does play out. But you've also touched upon something Maria brought out as well, which is that distinction that one often hears between implicit and explicit, and how far one can go in operationalizing human rights implicitly. And perhaps the guiding principles on business and human rights have a virtue in spelling out, perhaps teasing out a little bit more the specific implications of explicit. I just put that out there, but it might be an interesting question to come back to. I know that's a question that our next speaker, Motoko Aizawa, has thought a lot about. Motoko is currently the advisor to the Sustainable Development Network in the World Bank. She's an expert on environmental, social, governance dimensions on sustainability, as well as policy initiatives to help governments and companies improve their sustainability performance. As many in this room probably know, Motoko was the principal author of the 2006 Ifc Sustainability Policy and Performance Safeguards. That's the International Finance Corporation, and the human rights provisions of the 2012 revisions of the sustainability framework this year. For her sins, she is now also leading the World Bank's effort, if I could put it that way, correct me if that's wrong, to update the environmental and social safeguards of the World Bank, a exercise which has just publicly been announced and will carry on for the next 2 years or so. So Motoko's thoughts are going to be on the IFC performance standards, the World Bank performance standards for PPP projects, and the safeguards review. And I think we'd all be intrigued to hear how that private sector experience and the guiding principles as an influence on that in the IFC might even translate to the experience of the safeguards review process in the IDA, IBRD. Thank you.
Thank you, Mac, for that introduction. Good afternoon, distinguished participants and friends. It's very humbling to be sitting in front of you to share my experience at the World Bank Group. I'm also very happy to be in this room with so many different diverse perspectives and experience. I thought I would just start by stating the obvious, that the World Bank Group is a group of different institutions. So the World Bank part is engaged in public sector financing, mostly. So the funds go directly to governments or agencies then pass on the funds to contractors for implementation of projects. So the World Bank part has the part that lends to the richer countries and the part that lends to the poorer countries. And then there is IFC, International Finance Corporation, which lends to companies in emerging markets directly. And then there is MIGA, which is Multilateral Investment Guarantee Agency, which provides political risk insurance. So I'm going to be speaking both from the perspective of the side of the institution that does lending directly to governments, and also the side of the institution that does lending to private sector, because these are both publicly funded financing mechanisms. First of all, I just want to say that the World Bank Group inquiry into the intersection of its work on economic development and human rights has been spread over several decades. Operationalization has been a very challenging thing, as many of you know. This is not to say that the bank group has not had expended notable efforts in this area. For example, in the 1990s, President Wolfensohn has had a very significant initiative which basically recognized that the bank's development work, particularly in the poverty area, enables an environment in which rights can be fulfilled and enjoyed. Also at IFC in the early 2000s, the initiative led by Peter Voike and the Compliance Advisor Ombudsman Office on awareness raising, I think, was seminal for IFC. Nonetheless, it was really John Ruggie that provided the impetus for the World Bank Group to go further. It was John who gathered the fragmented initiatives, practices, and advocacy from the corporate side, from the civil society, and the public sector, and gave a compelling narrative that we know today as the guiding principles. And as you know, the big chunk of the guiding principles addresses the business responsibility to carry out human rights due diligence. But I should also just recall that in the state duty to protect section of the guiding principles, there are a couple of interesting sections. One has to do with the intersection between business and a state. So under that heading, the state has the additional duty when it supports export credit agencies, official investment insurance and guarantees activities to promote the guiding principles. Also, there is an explicit reference to states' duties as members of multinational organizations. And there's a positive duty and a negative duty. The negative duty is to seek to ensure that these institutions do not hinder states' duty to protect or business responsibility to respect human rights. And on the positive side, states are to encourage these institutions to do capacity building to help states meet the duty and the businesses to meet the responsibility. So these are two sections in the state duty side that is actually relevant for, I think, for publicly financed institutions. And so with that in mind, I just want to give you several examples of past and ongoing World Bank Group initiatives and activities that have a bearing on the guiding principles. And so I start quite obviously with the Ifc Sustainability Framework, the 2012 version, which got updated and became effective this January, has a recognition of the business responsibility to respect human rights, as well as, and that responsibility is independent of state duties. And there is a recognition of IFC's commitment to carry out appropriate due diligence in this regard. The performance standards which are applicable to IFC clients have a statement on business responsibility to respect human rights and a statement of an expectation that they carry out due diligence in accordance with the performance standards, and in some high-risk situation that there should be a tailored human rights due diligence. And then throughout the performance standards, there are various human rights concepts that are woven in, such as the need to look after those who are vulnerable, labor rights, gender, disability, right to housing, indigenous people's rights, right to culture, religion, etc., etc. And then there is a very distinct section on company-run grievance mechanism, which is mandated, which is also a risk management mechanism, as well as a mechanism to remedy human rights violations on the spot, if possible. I don't have the time today to go into the institutional level grievance mechanisms, such as the Compliance Advisor Ombudsman at IFC or the Inspection Panel of the World Bank. But these are, I think, quite familiar to many of you. But what happened with the IFC performance standards is that usually there's a knock-on effect. There are others who take up those standards. And so the Multilateral Investment Guarantee Agency, MIGA, is planning to take up the standards, the updated one in January of next year. The OECD export credit agencies have just updated their common approaches so that there's an explicit reference to both the guiding principles and the performance standards. And as many of you know, the Equator Principles 3, also known as EP3, is expected to come into being next year, in which also there should be an explicit reference to the performance standards and the guiding principles. Now, moving on to the World Bank side, Mac alluded to the fact that the World Bank this summer adopted the performance standards identical to the IFC performance standards for World Bank support or finance to public sector, in private sector projects, in public-private partnerships, in infrastructure projects. I should clarify that the driver of this was not a human rights driver. The driver was to ensure a level playing field and ease of operation between various actors, most of whom we assumed would be familiar with the IFC performance and the Equator Principles. And as a result, there should be a much more level playing field. But the interesting thing about it is that this could potentially apply to state-owned enterprises, particularly very large-scale state-run utility companies. Because we think that they're a very good candidate that can operate with the performance standards for the most part. Moving on to capacity building, I think some of you are also familiar with the Nordic Trust Fund, which helps with our internal capacity building and knowledge agenda on human rights. This essentially connects our implicit and the explicit agenda within the World Bank so that the development activities which are supportive of human rights can actually be expressed in human rights terms. And finally, I just would like to inform you of the World Bank's process of updating its safeguard policies. We kicked off this process over the summer. The approach paper is now publicly available, and we are in the phase 1 consultation mode. This is a 2-year process, so we hope to be finished by the year 2014 in the summer. What we want to do is to update the safeguard policies which apply to the bank's public sector engagement so that they are strengthened, the effectiveness is strengthened, and so that the development outcome and results can be enhanced. We are going to do this through creating an integrated framework, which means we are going to have a slightly different policy architecture from the current safeguard policies. We're going to have hopefully a chapeau statement, an overarching statement, just as much as the safeguard policies, separating policies from procedures, from guidance. So you can look forward to a multi-tiered policy structure. We are going to be looking into the fundamental principles of the safeguard policies, and keeping those, and also investigating new areas. So there are 7 emerging areas that we're looking at, including human rights, labor, occupational health and safety, gender, disability, the free, prior, informed consent of the indigenous peoples, climate change, and finally what I call the land nexus, which has to do with land use, land tenure, natural resources, biodiversity, ecosystem services, right to food, that entire nexus, which is just about everything. It's very interesting and instructive to see the NGO statements coming in and advising us on how to handle these issues. And it's not just human rights, but just about 7 of these areas have a consistent human rights expression, which means that we are instructed to understand these issues through the human lens, whether we call them explicitly human rights or otherwise. So I just want to acknowledge that this is ongoing. Your advice and your guidance throughout our process is going to be very, very important. We hope you can participate in one form or another. I particularly would like to suggest that if opportunities arise, that you engage with your state authorities about their state duty and how there are specific things in the guiding principles that instruct state when they deal with these publicly funded financial institutions. And so with that, did I do it within 7 minutes? Thanks, Mike.
Not quite, but you came close, but I couldn't cut you off during that last particular part of your conversation. I think that's such an important process to follow and be involved in. So thank you very much for a very fulsome presentation, a lot to react to. At this point, for those who've come in the room in the last 20 minutes or so, just a reminder, if you didn't know, that the speakers list is over that side of the room to my left, where colleagues from OHCHR are waiting to take your names. For those of you who want to make an intervention from the floor, maximum 2 minutes shortly. There is no other way to make an intervention. Moving straight to our final 2 speakers, it's my pleasure to introduce Kirsty Genovese from the Center for International and Environmental Law. She is a senior attorney for SEAL's International Financial Institutions Program and directs the Law and Communities Program. She is providing legal support, has been providing legal support to sugarcane workers in Nicaragua affected by chronic kidney disease to help determine the cause of the epidemic and obtain access to health and social services. She has also worked with mining-affected communities in Mesoamerica, Colombia, and Bolivia. Kirsty will be talking about the World Bank Safeguards review process from a civil society perspective and what SEAL and others might like to see come out of it. Thank you very much.
Great, thank you so much. It's an honor to be sitting on this distinguished panel at the forum. Again, I work for the Center for International Environmental Law, which is a nonprofit organization with offices in Washington, D.C. and Geneva. We've been working to try and hold the World Bank accountable to those people that are affected by the projects it's financed for the last 20 years. So this is a continuation of that work. Often when the World Bank speaks about human rights, it describes its activities to help states fulfill their human rights obligations by providing access to health care and education. We heard as much from President Kim in Tokyo at the World Bank annual meetings just recently. And of course, that's a very important aspect of their work. But we know, and the Committee on Economic, Social, and Cultural Rights has recognized that development projects don't necessarily always have a positive impact on human rights. They can also negatively affect human rights. And of course, one look at the case history of the inspection panel at the World Bank will show you that the World Bank finance projects can have a very negative adverse impact on the human rights of communities around the world. They've had 82 cases in the last 18 years. And that's where the safeguard policies come in. The safeguard policies are really, their objective is to protect communities and their environment. A lot of them were developed precisely as a result of these projects that had adverse human rights impacts, and they were hard fought. And they are often seen as the leading standard in development finance. But we know that they need to be updated. As Motoko just said, the World Bank has launched a review of all of the environmental and social policies of the World Bank. We know that there are gaps since they were first developed. Some of them are over 20 years old now. And so it is a singular opportunity to really ensure protection for communities around the world, for the bank to reclaim its leadership as a standard-setting body, and for the member states of the World Bank to meet their human rights obligations. And so as Motoko alluded to, member states do not leave their human rights obligations at the door of the boardroom, nor when they sign loan agreements. Member states can't collectively create an institution to do what they are otherwise prohibited from doing as a result of their international legal obligations, including their human rights obligations. As a client, as a borrower of the bank, governments must respect human rights in implementing a project. As member states, they have human rights obligations to protect against human rights violations of others by using their voice and vote on the board of the World Bank to adopt policies and to approve projects that are consistent with human rights. And as you can see here, the commentary to the guiding principles mention the human rights obligations of states as they participate in international institutions, including international financial institutions. This duty is supported by the Maastricht Principles on extraterritorial obligations. And here at the bottom is a photo of the board of the World Bank taken in 1949. The picture here, I think, looks a lot different from what we might see today in the boardroom. Maybe Motoko might confirm that. There's certainly more women, and there are more representatives from developing countries. And we need one of those countries, actually we need more than one of those countries, to be the champion for human rights at the bank, because it's at the board of the bank that adopts these policies. And of course, the people who sit on the board of the bank are different people than the people that come here to the forum. And so I think the policy coherence is a really big, important question that we need to get at. Of course, complementing the state's duty to respect human rights is the World Bank's own human rights obligation, which is, I guess, still potentially an open question as to the extent of that obligation. But as a UN specialized agency, the World Bank Group has a responsibility to act consistently with the UN Charter, which requires universal respect for and observance of human rights and fundamental freedoms for all. Also, the International Court of Justice has recognized that international obligations are subjects of international law and, as such, are bound by any obligations incumbent upon them under general rules of international law. Up until now, the bank has chosen which international law they will respect. Through their safeguard policies, they've recognized some indigenous peoples' rights, for example. They have not recognized labor rights. In the past, I think it's been used as the Articles of Agreement of the World Bank Group has been used as an excuse for why the bank can't deal with human rights issues. But through successive interpretations by the World Bank General Council, I think they've hopefully addressed this concern, and we're able to move on to have this discussion. So back to the safeguard review. As Motoko mentioned, it's a 2-year process. And I guess the question is, do we have any indication of where we might end up after 2 years? So if past is prologue, I think we need to look to the IFC's performance standards, and they've been receiving a lot of attention here at the forum as well as elsewhere. And I think I would urge us to be very cautious about what it is from the IFC that we want to take as a model in the World Bank Safeguard Review and elsewhere, and what parts of the IFC model perhaps are not as useful in the perspective of human rights. So, for example, the IFC performance standards does have a better coverage of human rights issues. So they do have a labor standard, for example. And the policy of the IFC does recognize the corporate responsibility to respect human rights. on the other hand, there is no mandatory human rights due diligence requirement. And one issue that we thought was, oh, thank you. So one of the issues that we thought was a win during the performance standard review was the recognition of free, prior, and informed consent for Indigenous peoples. But as we're seeing the projects roll out that are now governed under the new performance standards, we are concerned about the IFC's interpretation of the right to free, prior, and informed consent, which seems to be only limited to the design of the project and not to the project itself. So if the government has granted a concession for a mining concession on Indigenous land, and the client of the IFC, the corporation, the mining company, is going about developing that mine, really the policy is only designed to get to whether or not the Indigenous community would consent to the design of that mine and not the concession of mining itself. So I think that's problematic. Then the architecture of the IFC, I think, is over-reliant on self-reporting and self-monitoring from clients, and there is a shift from prescriptive requirements to a focus on systems, which I think leaves communities and the environment vulnerable. Just recently, earlier this year, the IFC adopted the World Bank Group adopted a new lending instrument called Program for Results Lending. This is the totality of the environmental and social requirements for that lending instrument. As you can see, it's not very detailed. It's at the principal level. And we're very concerned that these safeguard requirements leave communities vulnerable. And then most recently, the World Bank has conducted a consolidation of over 47 policies on project appraisal, supervision, and monitoring into one policy. And it has moved over 50 requirements that had been binding into non-binding guidance. So this multi-tier architecture that Motoko mentioned, I think is very concerning for us because a lot of the requirements that had been binding are now potentially no longer going to be. So here's what we want. We don't want the World Bank to create its own standards. We don't want the interpretation left to World Bank staff or borrowers. There should be a floor to protect communities and the environment, and that floor should be international law, including human rights requirements. I guess, as for your question, Mac, I'm leaning more on the favor of explicit recognition of human rights requirements, because then we have a common understanding of what those requirements mean. Communities will understand what they can expect from the bank, and so that FPIC isn't left to the definition of the bank. It's what international law says it is. So we want clear objective requirements. We want a real binding human rights due diligence. But we want it to be across all of the lending activities of the World Bank Group. So these safeguard policies will only apply to investment lending, to the project finance, which is a shrinking percentage of the bank's portfolio. They also have development policy loans, they have the program for results, and they have technical assistance, which are all governed by their own policies. And human rights needs to be incorporated across the spectrum so you have a consistent protection for communities and the environment. We know this is not going to be easy. Governments are going to have to step up to their obligations. And unfortunately, we can't rely on convincing Motoko of the value of incorporating human rights into the safeguard policies. We have to convince the member states. We have to convince the United States. We have to convince Brazil and China and Saudi Arabia. And so I would urge all of you here to engage with your governments, just as Motoko suggested, and engage in the safeguard policy to make sure that the ultimate policies do respect human rights, because it is time. Thanks.
Thank you very much. Thank you very much, Kristen, and for just about perfectly keeping to time. That's greatly appreciated. I heard Motoko scribbling feverishly to my right, and I think I even heard her nodding when you were talking about the executive board politics, the rocks upon which many a good argument tend to flounder. But those, I think, are very pertinent, well-made points. Thank you for those. Finally, penultimately, I should say, Our next speaker is Keenan, who's a program officer at the Halifax Initiative, which, of course, many of you know about, a Canadian coalition of over 20 development, environment, faith-based human rights and labor organizations. Karen has over 15 years experience working in environmental and social justice NGOs, both in Canada and abroad. Her work in Peru and Bolivia focused on environmental impacts of mining, and she's also been involved with Canadian national roundtables on corporate social responsibility and Canadian extractive industry in developing countries as a member of a multi-stakeholder advisory group. Without further ado, Karen.
Thank you. I'd like to start by thanking the working group for the invitation to speak, but also congratulating the group for its decision to include finance and the role of financial institutions in this forum. There's another session tomorrow that deals with private sector financial institutions. Public financial institutions joined the human rights debate relatively recently and with some reluctance, yet they have clear human rights obligations, and they wield extraordinary leverage over commercial sectors and projects that are associated with a high degree of human rights risk. My comments will focus on domestic financial institutions, particularly export credit agencies, which provide financing, guarantees, and insurance for exports and investments, including in developing and emerging economies. And I also want to say, despite the best efforts of the working group, unfortunately, we don't have a representative of an export credit agency here on the panel today, which is too bad. I also just want to mention that at the back of the room on the desk, you can find a handout, if you're so interested, that was prepared by ECA Watch, which is a network to which my organization belongs, and Chris's organization and BankTrack, that includes some analysis regarding financial institutions, both public and private, including some recommendations about how they can ensure that their operations are consistent with international human rights norms. I've organized my comments around 3 questions. First of all, what do the guiding principles have to say about domestic financial institutions? Are these institutions in line with the guiding principles? And if not, what should be done? So first of all, the guiding principles. The principles instruct states to ensure that governmental agencies, including export credit agencies, which are explicitly named, observe state human rights obligations when fulfilling their mandates. They explain that government agencies put themselves at risk in reputational, financial, political, and legal terms when they fail to explicitly consider the adverse human rights impacts of the business enterprises that they support. To mitigate this risk, the guiding principles advise states to encourage and, where appropriate, require human rights due diligence by government agencies and the business enterprises that receive their support. In fact, states have an obligation to ensure that human rights due diligence is undertaken by their agencies as part of the state duty to protect. The guiding principles also emphasize the importance of transparency and the need for public reporting on how human rights risks are addressed. Finally, the guiding principles call on states to ensure the effectiveness of domestic judicial mechanisms, including considering ways to reduce barriers that could lead to a denial of access to remedy. So what's the state of play with domestic financial institutions? States and their domestic institutions have failed thus far to align their operations with the guiding principles. I know that's a categorical statement, but I'm unaware of any exceptions, and I'd be very happy to be proven wrong if any of you know otherwise. There are no legal or policy guidance that exists at the national level to ensure that export credit agencies observe state human rights obligations. At the international level, members of the OECD develop shared policy guidance regarding export credit agencies in the form of a non-binding recommendation commonly referred to as the Common Approaches. Those of you who were at the Human Rights Due Diligence session last night or the Assembly this morning will know that the Common Approaches were recently revised and now reference for the first time human rights. There is a passing reference to the guiding principles in the preamble, but the recommendation does not call for their implementation. Among other shortcomings, it does not require robust human rights due diligence by export credit agencies. While some export credit agencies claim to undertake human rights due diligence, there is no transparency regarding either the policies or processes that they employ in this regard. In Canada, the country I know best, is an excellent illustration of this. Many of these agencies continue to finance investments associated with adverse human rights risks and impacts. Finally, states lack meaningful avenues, whether judicial or non-judicial, to provide the victims of publicly financed human rights abuse with remedy. So what should be done about this? I have several recommendations, again, that you can find in the document at the back of the room. First of all, states must adopt legal provisions that prohibit domestic financial institutions from supporting companies whose operations violate human rights. Public financial institutions must adopt transparent human rights policies that include due diligence processes effective in identifying and mitigating human rights abuse. These institutions must also disclose public information regarding the application of their human rights policies. And I really want to emphasize the transparency issue. Export credit agencies and many other domestic financial institutions are notoriously secretive. It's very difficult to get information from them about how they operate. Finally, states must provide meaningful opportunities for those whose human rights are violated by publicly supported activities to access remedy. States must make these opportunities known to affected individuals and communities. The central challenge is how to compel governments to take these steps. And I'd like to finish by suggesting that the UN Working Group can play a leadership role in this regard. Thank you.
Thank you very much indeed, Karen, and it's a sobering reminder perhaps of how patchy the patchwork quilt of convergence actually is. At the same time that the common approaches were being updated was the same time as the Ifc Sustainability framework was taking new form with very different treatment indeed of the guiding principles on business and human rights. Before we go into the discussion, I would like to invite Alexandra Gaketa, the presiding member of the working group, to offer us her thoughts and reflections. Thank you.
I'll be very brief in the interest of opening up the floor to questions and discussions. I take Motoko's invitation for the submissions and the focus and emphasis of those submissions. Now, one question I wanted to ask all of you were, and some of this has already been fleshed with reference to the boards of public finance institutions, but what are the opportunities, the priorities for integration and coherence inside the institutions with regards to the incorporations of the guiding principles? Because in all of these institutions, as in private corporations, as in government, as in international organizations, you will have different sections doing different things. And part of the key is that integration, so that they reinforce each other as opposed to blocking each other. So I would like to ask you about the priorities for internal coherence in public finance institutions. The other thing I would like you to share with us, if you can, I'm aware that public finance institutions sometimes meet to learn collectively, share notes. And so I would like to have a sense on how much other public finance institutions from other regions may be also following the steps of updating their safeguards and their grievance mechanisms.
I wonder, in fact, there's a surprisingly small list of speakers. It might be practical to take the 4 speakers listed here, keeping strictly to 2 minutes, and then that will give the panelists approximately 7 minutes or so to offer their reflections on all the comments that come in, if that's an appropriate way to proceed. I'll invite immediately Ms. Maria Benedetta from Italy. You have the floor. Strict 2-minute limit, thanks.
Thank you for the floor, and thank you for this forum, which is considerable important for governments, as my government in Italy. I just wanted to stress that our government gives great importance to the OECD common approaches on ECAs. And I regret that the export credit agencies, I regret that there are some representatives of the civil society who are, let's say, critical towards these common approaches, but we believe that even if there is work to do in terms of implementation of guiding principles, UN guiding principles, and especially in the evaluation of impact of projects on social, on human rights and environmental and social impacts. We think that this is the way to improve the methods, the working methods of export credit agencies. So we think that the OECD is a good place where to work on this subject, and hopefully there should be an outreach also to other non-OECD countries. Thank you.
Thank you very much for that brief and very pointed comment. Could I invite Mr. Perry Lazard from the Indian movement of Tupaj in Bolivia to take the floor, please? Could you raise your hand if, I'm sorry?
I'm an indigenous person, a Quechua indigenous person from Bolivia, and I've been involved in the Human Rights Commission over and over, especially on the question of transnational cooperation, so I know what I'm talking about. First of all, from the presentations of the panelists, I have the following comments. Banks, whether they be private or public, are responsible for the economic crisis in Europe. And you haven't said a single word about the financial crisis, about debt, about speculation. The banks have speculated on the stock exchange and Wall Street. And they caused a disaster for people all over, especially indigenous people. Secondly, I'd like to say to the World Bank, they've told us wonderful things about the World Bank, but that's not so. Here in this room, the World Bank has come here several times, and they've said that we're not interested in human rights or indigenous people. We're here to do business. That's what they've said, and I've personally heard that here in this room. The World Bank is in the hands of a major power, the United States, and they oversee that economic and financial policy. I'd like to say two things. The World Bank has been discredited because it has polluted the air, the water in developing countries. They've built pharaonic projects such as huge dams, roads, to provide access for multinational corporations. And in addition to that, they're involved in the sterilization of indigenous women in Peru and Bolivia. That's the World Bank. They're involved in that sterilization. These are crimes against humanity. We as indigenous peoples and many peoples and even governments of the third world have called for a review of the practices of the World Bank and International Monetary Fund. The Western countries have supported this, and the third world countries have never really benefited from this. The banks are responsible for the crisis in Greece, and they're responsible. In fact, here we've come to discuss a legal framework to regulate the activities of financial entities. That's the mandate of the forum, to prepare a legal framework to regulate the activities of that sector. And I'd like to remind you of one further thing. In the years 2000, there was work done in the subcommission, and they submitted their work to the commission, and that document just disappeared. So the exercise that you'll be doing in the working group will be just the same. The same thing will happen, and there'll be no positive outcome. Thank you.
Thank you very much for those very challenging remarks. We just have a few. I'm taking careful note of the comments coming in, and I think we should. We've been given a few minutes reprieve, so we'll just take the final 3 comments and then invite the panelists to respond. The next speaker is from Denmark, Ms. Birgitte Sander. Thank you.
Yes, thank you. I'm from Denmark, from the Ministry of Business and Growth, EKF, which is the Danish Export Credit Agency. I take note of the intervention made by ECA Watch, and especially that the common approaches which the OECD Export Credit Group adopted in June 2012 are not binding. Well, yes, they are not legally binding, but do not underestimate the effect of their political binding, and they were adopted unanimous by the export credit agencies within the OECD. Also, I just say when we assess a project, we are well aware of all the risks, environmental, social, labor rights, and also human rights. You say we are notoriously not transparent. I cannot speak for the other ECAs, but Denmark, we have adopted an openness policy in 2010, so I will recommend you to go to our website where we'll be able to provide information. Also, you must recognize that ECAs, they work in the realm between access to public information and also guarding the financial confidentiality our clients acquire. But let me say, during our review of the common approaches, we were addressed in June of 2010 by Professor John Rocky, and he gave us 4 proposals to ECAs, and I'm happy to inform you that in the current common approaches, we have adopted 3 of them. We now conduct and report human rights due diligence. In the updated common approaches, we've now integrated project-related human rights impact assessments in our due diligence for projects. We recognize the relevance of the human right, yes, in the preamble, but also if you look at the definition of social assessment, you will see human rights mentions and throughout the text. We also address the OECD multinational guidelines, as well as we mentioned the ILO core conventions. Furthermore, we have heard, at least from our clients, they're very happy with this approach, but also from other NGOs. At our last stakeholder meeting we had in November, it was Amnesty, who expressed that they were very pleased with this good first step that the ECAs had taken. And finally, we're building ECA capacity. We have a program for a future work, which is a 2-year program, where we will address how we can assess and address project-related human rights. Denmark has been very active in this work, and we will continue to do so. Now, you're probably wondering, I said that we had implemented 3 out of 4 proposals from Professor John Rocky. And the last one, just to be complete, is there is not implemented a risk of conflict indicators in the common approaches. But in all, we're just beginning, and I think 3 out of 4 is a very good result. Thank you.
Thank you very much. The second last speaker, and thank you for keeping just on the 2 minutes, greatly appreciated. The second last speaker is Mr. Ashley Erdman from Corporate Accountability International. You have the floor.
Thank you and good afternoon. As Mac mentioned, I represent Corporate Accountability International, a membership organization working to protect human rights and the environment from corporate abuse and to protect democratic policymaking spaces from undue corporate influence. And my question is specifically for the World Bank, and I would like to hear what steps in these upcoming processes the World Bank intends to take to address its negative impact on human rights, specifically the human right to water, by promoting public-private partnerships, which have continually shown to have undermined affordability, accessibility, and quality of water, and by the IFC taking direct equity positions in transnational water corporations. Thank you.
Thank you very much. And the final speaker, Mr. Thomas McInerney from Loyola University of Chicago. You have the floor.
Thank you very much. I want to pick up on a comment from the representative of the World Bank, but it also could be answered by any of the other IFIs. And the question is about land, and there was a reference to updating policies relating to land tenure and things of that nature. And I'm wondering, one of the things that struck me about the comments from the representative of FIDH this morning was how so many of the cases that she was referring to had to deal with, or had to do with land and disputes over land and natural resources. And one of the things that I haven't heard much about, or I haven't heard anything about so far this week, is the relationship between the voluntary guidelines on, the governance of tenure of land, fisheries, and forestry in the context of national food security, which was endorsed by the Committee on World Food Security back in May of this year. There are potentially many synergies between those voluntary guidelines and the guiding principles, and the voluntary guidelines have a lot of human rights provisions as well. So I'm interested to hear whether there's any efforts underway to integrate those voluntary guidelines into your overall approach to the guiding principles as well. Thank you.
Thank you very much for that brief and well-articulated question. We have about 3 minutes left for each speaker. There are two clusters of issues. One cluster concerns the World Bank. For Motoko, perhaps I won't recite them unless I need to. And the second cluster of issues from the floor, Karen took careful note of, I imagine. And each panelist was put a question also by Alexandra in terms of institutional policies. So I propose we start with Motoko and then move to Karen and then back in this direction. Thank you. 3 minutes each.
Thank you. Thank you very much for the diverse set of questions. Just addressing Alexandra's question and a challenge first. Just want to share with you the direction of the institution at the World Bank as articulated by the president. First of all, the safeguard policy update is part of an ongoing reform. There's a procurement reform. There's the larger investment lending reform that you already heard from Kristen. And all of these reform agenda involves a conversation about how do we shift from the World Bank, which sits in Washington, D.C., and tells our borrower governments what to do in return for our money, to the World Bank being able to support country systems, institutions, so that they have ownership in the entire sustainability agenda, so that it's not that we are in a mutually supportive partnership relationship. And this discussion, I think, is the direction that in which the larger institution is headed. It's indicative of our future direction. On the other hand, I know that many of you feel that the safeguard policies are there for compliance, and therefore the compliance responsibility falls squarely on the World Bank, and that is the World Bank's accountability. And so we're going to have to somehow create a mechanism where both of these directions and values and accountability expectations can be fulfilled. So this is a challenge going forward. I will just state it like that. I think I'm going to just leave it to Elena to perhaps describe how we might collaborate. There's a lot of collaboration and interaction and exchange of information. I think it's very valuable and instructive for all of us. I would just acknowledge the speaker's comments over there from Bolivia and acknowledge that there are impacts coming from whether the World Bank or IMF's macroeconomic guidance to countries. Also obvious impacts, both positive and negative, from projects that World Bank finances in countries. And that's precisely the function of the safeguard policies, to make sure that there are no or minimum negative impacts on the ground. I am just going to quickly touch on the question on water. So I'm not going to be able to comment on the specific investment instances that you refer to, but basically the intent is for us to support the right to water, right to access to water and sanitation through various mechanisms. So through investments, as well as engagement and dialogue with countries and stakeholders. We've had the opportunity to exchange information with the rapporteur on water and sanitation, for example, and we are basically trying to figure out how to support this important human right through our various lines of interventions. And finally, on the land question, so your point on the guidelines is very well taken. It's very much on our radar screen to look at the voluntary guidelines. We are also looking at the responsible investment in agriculture principles. We're looking at multiple different inputs because this is a cross-cutting issue, and as I say, there's a lot of intersection between land-related issues and human rights. So if you have any specific input on this matter, please come see me afterwards. Thank you.
Yes, if ever there was a growth industry in human rights that isn't wanted, that's it. Could we go to Karen for your comments? Thanks.
Thank you. So several things to respond to. On the question about whether the common approaches are more useful than I may have led those who are unaware of them to believe. The common approaches were originally developed to guide ECA operations regarding the environment, and only very recently were social or human rights concerns incorporated into the document. And in the, over a decade since we've had the common approaches, there have been any number of exports and investments that have been financed by export credit agencies that have had severe, lasting adverse environmental impacts, and for which affected communities have sought recourse through judicial and non-judicial mechanisms, mostly unsuccessfully. So I'm skeptical about the common approaches. I believe it's useful for states to work multilaterally, perhaps even through the auspices of the OECD, but I think they can do better. Let's recall that this is officially the characterization of this agreement is a gentleman's agreement. That is how it's characterized by the OECD. It's non-binding, and there's a derogation clause. So states can at their discretion, remove themselves from its application. On the issue of the Danish Export Credit Agency, I'm very excited to hear that Denmark discloses information about how it assesses potential human rights impacts, and I'd like to learn more, and I'd like to take that information to the Canadian government. On the issue of transparency and commercial confidentiality and the difficult position that export credit agencies are in, those of us who work on export credit hear this a lot. Again, the case that I know best is Canada, and in Canada there is a presumption against disclosure. There is no obligation for a private sector client to demonstrate to the export credit agency that information is commercially confidential and that its release would be prejudicial. That is just assumed writ large by the export credit agency. And so it's up to people like me to make the case that there would be no prejudice if information, the nature of which I am unaware, would be disclosed. So I understand that there's a balance that must be reached, but right now, at least in Canada, but I also hear this from many of my European colleagues, unfortunately export credit agencies seem to be erring on the side of a bit too much confidentiality. Regarding what I said about the common approaches and human rights, what I said was that there is a passing reference in the preamble to the guiding principles. And I'm aware that human rights are mentioned in the body of the common approaches regarding safeguarding of projects. Unfortunately, the reference point for human rights due diligence in the common approaches regarding human rights are World Bank standards, not international human rights norms. And there are a number of other concerns regarding how the common approaches instructs export credit agencies to deal with human rights. And if you're interested, I'm sorry, I don't know where you're sitting. I'd be happy to talk to you about it afterwards, but I have concerns. Finally, about amnesty. I have a document here, and I can share the number with you. It's recent. It's November 12th, 2012, where Amnesty expresses its extreme disappointment with the common approaches and the fact that the OECD failed to incorporate the voluminous input that Amnesty prepared during the process of reviewing the common approaches. So if you're interested in seeing that, again, I'd be very happy to share it. Thank you.
Thanks very much, Karen. We're down to just a few minutes to go. Perhaps we go out to Maria, if you would like to give us a few final reflections of your own in response to Alexandra's question or otherwise. Then Kristen, and then down to Eleni. Thank you.
I wanted to briefly comment on 3 points. One was in response to Alexandra's question on priorities for coherence. I think that we see that priority arising in looking for the intersection between the private and the public space where we work. I think finding ways, whether it's through regulatory, I think it's a combination at the end of regulatory and voluntary instruments to have more of a level playing field and to have companies leverage their presence in areas that have a lot of development needs to also leverage public funds to invest, to meet those demands which often have to do with meeting basic human rights. As far as intention of other public finance or private finance institutions in terms of changing their policies, we've had recently in Latin America some very good experiences and exciting experiences with both the regulatory side and the public banks in Uruguay, Peru, and Colombia especially, adopting safeguard systems somewhat similar to our own. Not so much, again, the explicit human rights agenda, but at least starting to meet the environmental and social safeguard standards that the MDBs already apply for us. That's very important, and IFC also has done a lot in terms of having the private sector and perhaps less because of their role in the private sector, the public banks, adopt those systems. At the end of the day, I think moving to systems, whether it's in the financial system or in the governmental and regulatory systems, is really the only way to have greater impact on development in general and on the quality of that development, because even if we were to get our projects perfect, and I'm far from saying that we do, when those projects end, the context sometimes doesn't change, because my experience shows, working on a lot of projects, that we have to put in a lot of executing units and special measures to make sure that we meet those safeguards. But when the project's over, they're not necessarily sustainable in that context. So working from the systems, even though we may not get the results we want up front, may in the long term generate better results for all of us. And finally, just briefly about the gentleman who remarked on the voluntary principles on land and fisheries. We try to look, that's another space, I think, for coherence and cooperation. Like the World Bank, we're trying to work with a lot of the voluntary industry groups in agriculture, in mining, in hydroelectric. We just sponsored a big meeting in Brazil about with the hydroelectric industry to try to converge the regulatory space with the voluntary principles, and to use the voluntary space as a place to learn what makes sense in terms of regulation and in terms of social responsibility, and how to combine those initiatives to generate better results.
Thank you very much, Maria. Christian, your last thoughts, please.
Thank you. 3 points. One on internal coherence of the bank, Alex's question to us. I'm concerned that the World Bank is missing the opportunity by not incorporating the lessons learned from the inspection panel of the bank. As I mentioned, the human rights are explicitly or implicitly raised in almost all of the inspection panel complaints. The inspection panel is on the ground. They see whether and to what extent policies protect communities. But yet the panel has not been given a formal role in the safeguard review, similar to what the compliance advisor ombudsman was given during the IFC's performance standard review, and I think that's a big missed opportunity for the institution. The second point, just on supporting country systems, we would agree, and I don't think that there is anything inconsistent with adopting human rights standards. In fact, I think if adopting human rights standards would actually help the countries who have ratified human rights treaties in the fulfillment of those obligations. And just a third point on how we measure the adequacy of these policies that banks adopt. I hear, and you hear various times that, oh, the IFC performance standards are really successful because look how many institutions have adopted them. Or you see in the safeguard approach paper at the bank, we want to increase country ownership of World Bank projects. We want to expedite the time it takes to approve loans. The measure of how well policies work is whether or not the rights of the people affected by those projects are respected. And we still see the human rights violated because and as a result of projects that are financed by these banks. So as long as there are human rights violations that come as a result of World Bank financing, there's a problem with the policies. And that's how you measure the adequacy of those policies. Thanks.
Thank you. And Eleni, you have the invidious task of commenting last, if you would, including perhaps on the challenging question of incentives. Thanks.
Quick responses. I'll start with the most straightforward one on the Fao Voluntary Guidelines. These constitute an example that of guidelines that we bring into our work to actually flesh out and give more substance and content on specific issue or theme-based concerns that we may have in our due diligence. So it's like them, it's the voluntary principles on security and human rights. There are loads of issue theme-based guidelines out there that we bring in our work. Opportunities and priorities for cohesion and coherence institutionally. I think in our case it is interesting that the one department that was targeted for revising or embedding human rights in its work was the one that was undertaking environmental and social due diligence. So, at least in the case of the EIB, we start from a very particular and small sphere of due diligence. In our scope, or in our very personal scope of our division, there are, of course, suggestions of spreading out and not allowing silos, because I think it's not so much a matter of one department blocking the other, rather than of not facilitating the work that is undertaken in one department. Remains to be seen. I'm talking about incremental change here. And final point on coordination across MFIs on this topic. About a month and a half ago, the EIB hosted an MFI meeting of social development specialists. It was specifically themed on the opportunities and challenges of embedding and mainstreaming human rights in our due diligence, and I'm very happy to say that it was an extremely fruitful exchange of similarly thinking minds. So what I can share at this point is that there is spread across institutions a concern about how to engage with human rights, as well as an equal soul search over the extent to which our current practices fulfill that obligation, and where the difference lies and what we need to do to bridge that difference.
Thank you very much indeed. Alexandra, do you wish to offer any final reflections? If not, we are encroaching on the 4 o'clock start time for the final session, so I'll bring this session to a close. I want to thank you all for participating and being with us, and a big thanks to our panelists who've traveled a long way to be with us today for a debate that a session like this can only capture a very small static snapshot of, but certainly we look forward to the continuing conversation with many of you here and supporting the working group in its quest to raise the bar on coherence. Thank you very much to you all.